For many aspiring to make the United Kingdom their permanent home, the goals have always been clear. First, achieving indefinite leave to remain, ILR, and then, for many, obtaining a British passport. However, the ground beneath the UK's immigration system is shifting significantly. These recent and proposed changes mean that for some, the path to settlement and citizenship may be growing longer and more complex. Furthermore, even those who have already become naturalized citizens could face new vulnerabilities regarding their status. This overview is essential for anyone currently on a UK visa, in the process of applying for settlement, or who is already a British citizen through naturalization. For a long time, 5 years was a standard period of continuous residence required for most individuals on work or family visas to become eligible for permanent settlement, or ILR. This offered a clear and predictable route to making the UK a permanent home. A significant policy proposal, however, looks to reshape this timeline. A government white paper, reportedly published in May 2025, outlines a plan to extend the standard qualifying period for ILR from 5 years to 10 years for a majority of visa categories. This would effectively double the time individuals must reside in the UK under visa restrictions, often tied to a specific employer, before they can truly settle. The stated rationale behind this proposal is to ensure that permanent settlement is granted only after a more prolonged period of contribution to the UK's economy and society. Who would be affected? This proposed 10-year standard is expected to apply to most work-related visa routes, including the skilled worker visa. There are, however, some important exceptions. The government has suggested that the 5-year path to settlement will likely be preserved for partners of British citizens on family visas and for victims of domestic abuse. Additionally, individuals with rights under the EU settlement scheme are protected by the 5-year rule as established in the UK-EU withdrawal agreement. For many others, the journey to permanency is set to become substantially longer. A decade-long qualifying period also increases the potential for complications that could derail an application. The grounds for refusing an ILR application remain stringent. Common pitfalls include excessive absences. Applicants must not spend more than 180 days outside the UK in any 12-month period. Tracking this over 10 years requires meticulous record-keeping. Tax discrepancies. With data sharing between the Home Office and HMRC, any inconsistency between your declared income and your tax records can be interpreted as deception, leading to refusal. Application errors. Simple mistakes, such as using an incorrect form or failing to provide a required document, can result in an outright rejection. Criminal record. All criminal convictions, no matter how minor they may seem, must be declared and can lead to mandatory refusal depending on the sentence. Immigration history. Any past breaches of immigration law, such as overstaying a visa, can negatively impact a future settlement application, regardless of how long ago the breach occurred. The message is clear. The path to ILR is becoming an endurance race, where every year of the journey is subject to close examination. For those who successfully obtain ILR, British citizenship is the final step. Here too, a significant policy update in 2025 has created a substantial barrier for a specific group of applicants. The change centers on the long-standing good character requirement. On February 10, 2025, the Home Office reportedly issued new guidance that has profound implications. According to this update, any citizenship application will normally be refused if the individual has ever entered the UK illegally. This includes arriving without the necessary visa or by what the Home Office considers a dangerous journey, such as in a small boat or concealed in a lorry. What makes this policy shift so impactful is the removal of the previous 10-year limitation. Formerly, an illegal entry that happened more than a decade ago was often overlooked. Now, the time elapsed is irrelevant. An irregular entry from 15 or 20 years prior could be used to deny citizenship, even if the person was subsequently granted refugee status, has built a family, and has been a law-abiding resident for years. This change is expected to heavily impact refugees and asylum seekers, many of whom had no alternative but to use irregular means to reach safety. Critics argue the rule penalizes individuals for circumstances that were often beyond their control and creates a tiered system of residency. Perhaps the most startling point is that holding a British passport does not guarantee it is yours forever. The government has the authority to strip naturalized individuals of their citizenship, a power known as deprivation. This power, outlined in Section 40 of the British Nationality Act 1981, is typically exercised for two main reasons. Fraud or deception. This is the most frequent cause. If it is discovered that you lied, used a false identity, or concealed important information, like a criminal record, during your citizenship or any prior immigration application, your citizenship can be revoked. Conducive to the public good. This is a broader power used in serious cases where the Home Secretary believes it is in the public's best interest to act. This is reserved for matters of national security, such as terrorism, espionage, serious organized crime, or war crimes. A crucial question is whether this can leave a person stateless. While international law generally prohibits this, the Nationality and Borders Act 2022 has expanded the government's powers. For naturalized citizens, the government can now proceed with deprivation even if it results in statelessness, but only if the person's actions have been seriously prejudicial to the vital interests of the UK. The Act also introduced the ability for the Home Office to revoke citizenship without prior notice in certain national security scenarios. This is not a theoretical risk. Between 2010 and 2023, over 1,000 individuals had their British citizenship revoked. The UK's immigration system is undeniably becoming more challenging. The route to settlement is getting longer, the criteria for citizenship are narrower, and the permanence of that status is more conditional than ever. So, what should you do? First and foremost, be meticulous and honest. Every application and piece of information you provide must be accurate and complete. In this stricter environment, there is no margin for error or omission. Attempting to mislead the Home Office is the surest way to face refusal and potentially a ban from future applications. Second, understand your entire immigration history. With new rules that scrutinize past events, you must be aware of how every detail of your journey, including your first entry into the UK, could be evaluated years later. Finally, seek professional legal advice. The rules are intricate and subject to frequent change. Trying to navigate this system alone is a significant gamble. Investing in expert guidance is essential for securing your future in the UK. The dream of building a life in the United Kingdom is still attainable, but achieving it now demands more patience, diligence, and awareness than ever before. Stay informed and prepared to protect your journey.